Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to circle back now to the big challenge coming up in October for the United States Supreme Court on the ATF's rule as it relates to unfinished frames and receivers. Now, we already did this video right here, geeked out on it a little bit, really tried to boil it down to its most simplest point. There was a whole nother section of the video. I decided to pull it out because I was really trying to keep that video very concise. I went and shot it again, went home to edit it last night, did not like the way it came out, didn't like the messaging in it, so I decided I'm gonna redo it again. But for those of you who've never dipped your toes into the unfinished frame or receiver waters, for those of you who never built a firearm from an 80% lower, you may be sitting there thinking, well, this really isn't that big of a deal to me. But I'm going to pull something out of the Firearms Policy Coalition brief that I think we all need to be aware of, because this is actually a much bigger thing than you may know. So today, let me educate you and let's talk about how they could use the rule on unfinished frames and receivers to disarm a lot of you. Okay, so here we go. We're going to talk about the case of Garland v. Vanderstock yet again. It is set for oral arguments on October 8th before the United States Supreme Court. We've already done this video right here where we went through the Firearms Policy Coalition's opening brief. I said it was a very wordy brief, and I ended up pulling a big section out of the original video because I wanted to keep it kind of concise. And then after a couple of redos, here we go. But I want all of you to understand this. And again, the worst thing that you could ever be accused of out here trying to be a YouTube creator is being a clickbaiter, okay? And I do not ever want to be labeled as a clickbaiter. So the title was, how could they use the rule on unfinished frames and receivers to disarm a lot of you? Okay, now I'm gonna just assume that many of you who are watching this video have never built a firearm from an 80% lower. Great, I have not either myself, okay? But I bet a lot of you have armed yourself with semi-automatic rifles, those in the AR platform. I know I have. I'm willing to bet a lot of you have as well. All of them have serial numbers on them. All of them you filled out 4473s just like I did. Do you fall into that category? Because if you do, you need to listen to this video because this is the category of people that I'm talking about. Okay, so this is how it goes, and I want you to follow this, and we'll use these little handy-dandy diagrams here to help us out. There is a statute out there. It's called 18 United States Code, Section 921, subsection A. It has a lot of definitions. It's where most of the federal definitions as it relates to firearms laws are found. In there is 18 United States Code Section 921A, 3A and 3B. That is 2 of the 4 definitions of firearms. Why is that important? Well, because the only thing the ATF has the authority to regulate is a firearm. Now, we're not even going to pay attention to the 3rd and the 4th one because it has no application to this argument whatsoever, but the first 2 do. 3A, which is kind of your vanilla general definition of a firearm, reads as follows. Any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Okay, that's fine. Here's the second definition that's in place, and it's found in 3B, the frame or receiver of any such weapon. Now, if you just want to understand what the ATF's position is they are saying that even though the language or may readily be converted to is found only in 3A, it really permeates all the way through this definitional section into 3B. And therefore, a frame or a receiver is obviously a frame or a receiver or anything else which may be readily converted to be a frame or a receiver. You follow so far, right? But you see, the ATF's position is that the or may readily be converted to doesn't just permeate throughout this section of the United States Code. No. It permeates throughout all of 18 United States Code Section 921. Okay, but if that's the case, if you go to 18 United States Code Section 921, subsection 24, you find the definition for machine gun, but you don't really find it there. What you find is this. The term machine gun has the same meaning given such term in Section 26 United States Code 5845. Okay, and then if you go to 26 United States Code section 5845 sub B, you do find the definition of a machine gun, and it reads as follows. The term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. And then I want you to pay attention here. The term shall also include the frame or receiver of any such weapon, any part designed and intended solely and exclusively or combination of parts designed and intended for use in converting a weapon into a machine gun, and any combination of parts from which a machine gun can be assembled if such parts are in the possession or under the control of a person. Okay, so here's what the ATF is arguing. They are saying that an unfinished frame actually constitutes a finished frame. And of course, if you take a look at the AR-15, even as a finished frame, it is not that far removed from being a frame which could function on a fully automatic firearm. And then the Firearms Policy Coalition goes through and in numerous cases in their memorandum points out that if the ATF position were to be adopted, that an unfinished frame or receiver is actually a frame or a receiver, then an AR-15 receiver would actually constitute an automatic receiver because it is almost to that stage of manufacturing. If anything that can be readily converted to function as a frame or a receiver is a frame or receiver, then Americans who own AR-15 rifles, one of America's most popular firearms, run the risk of violating the federal prohibition on unregistered machine guns in the NFA. It generally is possible to convert AR-15 receivers to function as machine gun receivers, and the physical alteration involved in conversion may be as simple as drilling a single hole. Now, whether or not that is really that simple of an operation, I'm going to rely on all of you firearm experts to go ahead and weigh in down below in the comment section. And this is the one caution I would have given to FPC, and I did say that their brief was good, but it was wordy, is that the inclusion of this kind of language, as we will see in a couple other examples, could theoretically be used to beat us over the head should the tides turn in another direction. For example, if there is a federal assault weapon ban and a court that is not as pro-Second Amendment as the current highest court in the land. The brief also does correctly point out, but if a frame or receiver of a firearm inherently includes anything that can be readily converted to function as a frame or receiver, then unbeknownst to courts and the American public, many of the most popular, commonly available rifles in the country, according to Justice Sotomayor, contain a machine gun frame or receiver. This fact has the potential to make their owners and sellers felons in waiting, since AR-15 receivers sometimes can be converted to function as machine gun receivers simply by drilling a single hole. Again, a very effective argument, and this is the point I'm trying to make, is that if this position was ever adopted, now the federal government has a reason to go out and ban every single AR-15 lower in what would be one of the largest disarmament pieces of legislation ever. So this is the danger we have when we use, albeit a very good example, but the type of language that's included in this memorandum can come back and haunt us. The memorandum also points out, if the focus is on whether sufficient work has been done to designate an item as the frame or receiver of a particular type of firearm, for example, there is no risk of accidentally declaring AR-15 receivers to be machine guns. Until the hole that is required to turn an AR-15 receiver into a machine gun receiver is drilled, an AR-15 receiver is not identifiable as a machine gun receiver. So yes, if in fact the Supreme Court were to rule in favor of the ATF, that line of logic could likely be used to strip many of you of the most popular modern sporting rifle known to man. Now, before you start freaking out, and I always try to be really honest, let's get a couple of other things out here on the table that are realities here. Number one, the likelihood that the ATF is going to prevail in front of the United States Supreme Court is pretty remote. If you go ahead and you take a look at how the Supreme Court ruled in the matter of Cargill v. Garland, this is going to be very consistent with how we believe this United States Supreme Court is going to rule. It's probably going to go literally along the exact same voting lines. So the reality of this happening at the current time is remote. But that does not mean that this rule and this line of reasoning cannot come around once again. And that is how they could use the rule on unfinished frames and receivers to disarm a whole lot more of you. The case, once again, is Garland v. Vanderstock. We're going to link up the brief down below so that you guys can geek out on it for yourself. Maybe you got questions about this or something else related to what's left of our Second Amendment rights. You guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. Maybe you got an idea for a video we should be doing. Go ahead and click on that link right there and let us know, because most of the good ideas we have around here are not our ideas at all. Maybe you just want to sign up for our monthly newsletter. The ability to do so and how to do that is all down there in the description box. And then finally, and most importantly, America, let's everyone remember, the part of being the lawful and responsible gun owner, like we preach all the time here at this channel, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.